Good morning and welcome to the joint Minnehaha County City of Dell Rapids meeting of February 25, 2025. I will call this meeting to order and note for the record a quorum of members with Commissioner Karski absent. Before we get started, I'd like to remind everyone to silence your cell phone. And if you plan on speaking during public comment today, please sign in the back of the room with your name and address. This meeting is not able to be live streamed today, but I'm told the recording will be available on our YouTube channel later.
Call City of Del Rapids City Council to order and ask the Finance Officer to please call the roll.
Berg.
Here.
Meyer.
Here.
Nelson. Hawk.
Here.
Jones.
Here.
Hanslick.
Here.
Cavagelli.
Here.
Ronsagen.
Here.
Mayor Early.
Here.
Please rise for the Pledge of Allegiance. I pledge
allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay, first I will consider a motion to approve the agenda.
So move.
Second.
That's a motion by Benninga, second by Kipley to approve the agenda. All those in favor?
Aye.
Opposed? Motion carries.
Entertain a motion from City Council to approve the agenda.
Move to approve.
Moved by Chuck. Do we have a second?
Second.
Second by Cavagelli. All in favor signify by saying aye.
Aye.
Opposed, nay. Motion's carried.
That brings us to item number 2 on the agenda, which is a public hearing to consider an appeal of a decision by the Joint Planning Commission to approve conditional use permit number 25-02 to allow outdoor industrial storage. Kevin Hookman, thank you.
Good morning. I'm Kevin Hookman from the County Planning Department. This is a conditional use permit number 2502 to allow outdoor industrial storage. Staff did receive an appeal of the Planning Commission decision to approve the permit. The location of the property is at 24670 475th Avenue. And maybe we can kind of bring up that photo here. So we have a site plan to start it. There are a lot of materials. So this would be the highlighted area of the property. The Joint Planning Commission heard this item at the January 27th Planning Commission meeting. At that meeting, several neighbors and residents spoke in opposition to the request. The Planning Commission did amend 2 conditions for amend condition number 3 that requires vehicles and trailers to be licensed, then added a condition for a compliance date by July 1st, 2025 to review the property. At the meeting, both planning commissions unanimously approved the request for outdoor storage with the 11 conditions as amended. Since the appeal, staff received additional information from opponents we just kind of scrolled through, and I'm sure that we'll be able to go back to them. And staff also received an applicant submitted request to amend 2 of the conditions. The applicant's request is to amend condition number 3 regarding license requirements. It's more of a clarification of what needs to be licensed and what doesn't need to be licensed. And then condition number 10 requiring the pre-annexation agreement, where they are requesting that condition be removed from the conditions of approval. Right now, I guess I will go through some of the photos of the site. As you see, the existing site composed of mostly a former runway, this long strip down the middle here. The runway is going to be the primary area for storage, and not on the grassy area. Some pictures of the area. This is from the far south of the property here. You can kind of start seeing the runway right there and some of the storage in the background. This is kind of the furthest south of the storage area. The complaints for the storage largely revolved around the unsightliness and the character of storage items there, such as vehicles with flat tires or up on blocks. Or this bus is a concern because that has been there and inoperational for a couple of years now, from what was said at the meeting. And then you can see it starts transitioning into more camper storage, more typical of an outdoor storage location. The elevation of the road kind of goes up and down on the side, so depending on where you're located, the elevation of the storage area can be either above where your sight line is or below where your sight line is. And you can kind of see that in this picture versus this picture. And this would be looking across the street into where the entrance of this, right now I'm taking photos along Garfield Avenue because it's easiest to take photos of. The main access will actually be off of the state highway on the other side, which would be here. So there's the signage for the entry, and then this would be a nearby entry from the other side, just kind of show the area. So I'll bring it back to the whole site. So since this is an appeal hearing, and I think that since there has been some questions on the conditions of approval, if you don't mind, I think I'm going to go ahead and read all the conditions of approval since they've been amended. So condition number 1, the property shall conform to the submitted site plan. The planning director can approve minimal changes. Major amendments must be obtained to a new conditional use permit. Condition number 2, no human occupancy shall be allowed within any of the vehicles, campers, or trailers on the property. Number 3, all vehicles, campers, and trailers stored on the property shall be fully operational, intact, and licensed. Number 4, that all new driving, parking, and storage areas shall be hard surface in accordance with Article 15 of the 2001 revised joint zoning ordinance for Minnehaha County and the city of Dell Rapids. Number 5, that all new or replacement outdoor lighting shall be designed to prevent direct spillage of light beyond the property boundaries. Number 6, the building permits shall be required for any signage. Number 7, that access to the storage area be limited to the existing access on South Dakota Highway 115. Number 8, a rural address sign must be purchased from the county and installed in the driveway access. Number 9, that the Planning and Zoning Department reserves the right to enter and inspect the site at any time after proper notice to the owner to ensure the property is in full compliance with the conditional use permit conditions of approval and the 2001 revised joint zoning ordinance for Minnehaha County and the city of Dell Rapids. Number 10, the applicant must sign pre-annexation agreement with the city of Dell Rapids on or before March 28th, 2025. 11, the property shall be compliant with all conditions of approval prior to July 1st, 2025. And with that, I will note that this is an appeal hearing, so the county commission and city council can uphold, deny, or amend the joint planning commission approval for CUP 2502. And I'm here for any questions.
Thank you, Kevin. This is a public hearing, so at this time, we will hear from the proponents first, followed by opponents, and we will have time for rebuttal if necessary. And as a reminder, if you'd like to address the commission and council, please make sure you signed in the back. You only need to state your name and your county of residence before speaking. Any proponents?
Hi, good morning. My name is Tommy Johnson. I'm a resident of Minnehaha County. I'm here today on behalf of the landowner and petitioner and the proponent of the conditional use permit. My client, of course, agrees with the issuance of the conditional use permit and agrees with the staff analysis, staff report that Kevin provided. simply requesting what I would deem small modifications to the conditions. One of which was condition number 3, which actually was not in Kevin's initial staff analysis report, but it did come out of the amendment to the condition at the joint hearing. And that condition has to do with licensure. So the request is to the removal of the licensure requirement, still keeping all of the same conditions with respect to the vehicles and campers need to be fully operational, intact, not unsightly, et cetera, but simply remove the licensure requirement. What my client has found in discussions with some of their tenants who store property is, even if some of the campers and other property that are stored out there are fully operational, intact, they don't always keep them licensed on a year-round basis. So what we're creating is a scenario where we have kind of what I would call inconsequential noncompliance with the condition. So I have proposed modified language, I believe, which was submitted to you prior to this hearing, to condition number 3 to remove the licensure requirement. The final request for amendment would be the removal of the requirement that the landowner sign a pre-annexation agreement. This is a request for a conditional use permit for outdoor storage. The pre-annexation agreement, I don't believe, is in any way, shape, or form connected to the proposed and conditioned use. So the landowner would simply request the removal of that condition from the permit. Thank you. That's all I have. If you have questions, I'm happy to answer them.
Thank you. Any other proponents? Seeing none, we'll move to opponents. Anyone who would like to address the council and commission?
My name's Dan Richardson. I live right on the south end of this property. I'm gonna just back up here and give you some insight into how this all came down. The property in question is zoned light industrial, which says no outdoor storage. That's, when we all built our houses and our businesses, that's how it was zoned, no outdoor storage. It's year by year been getting less and less policed to where now it's starting to turn into a junkyard. Not just where the campers are, but there's several others that aren't complying either. The regulation states it is intended to preserve and protect existing property uses and values against adverse or unharmonious adjacent uses. I fail to see how this is going to do that with my property or any of the other houses. Turns out there aren't 5 and 2, there's actually 10 houses that will be affected, and 15 houses and approximately 15 businesses. I got a petition signed. You should have it in your packet, I would guess. I didn't find anybody that wanted it there, to tell you the truth. Not one. Okay, as we went along, then the notary was notified that they were in non-compliance. They asked for a conditional use permit. We met, they approved it, and that brings us here. 701 of the regulation between the agreement between you two commissions states light industrial district. Intent, this district is intended to provide for a number of light manufacturing, wholesale, warehouse services in an attractive industrial park-like setting. And you can actually see that in part of it. Somebody built storage buildings. On the north end, they look very nice. They've got a gate, keyed gate, looks good, no problem. And that brings me to no licensing. If you don't have to license them, they're not going to use them. So they're not there to be just used on a basis in and out during the year. They're just looking for a place to warehouse them. So the licensing thing should stand. Another 7.02 says permissive uses, public utility facility, electrical substation, offices, bank or financial institutions, indoor recreation facility, antenna support structure, mortuary, nursery, or greenhouse. I didn't see outdoor storage here anywhere. Permitted uses, communications, warehouse, repairs. There is no outside storage on the premises. That's 7.00A. And sub F is retail, sales, trade, personal services, communications facilities, and warehousing, provided there's no outdoor storage. Okay, and if this conditional use permit is let stand, then we have all sorts of other things that kick in. 15.00 is parking and loading regulations must be enforced. There's actually a standard to what that blacktop has to be. And if we were to scroll back here, the campers now are not parked on the blacktop. I want to see all these pictures so we can see exactly what it is.
Are you looking for your slides? Are you looking for your slides?
No, yours are fine.
Okay.
This property on the north end, that's the place I was telling you about, that you can see what the storage of, outside storage of campers look like compared to the storage facilities with a gated, fenced-in facility. As the parking goes, somebody from, some engineer, somebody's gonna have to determine if that parking meets the requirements as spelled out in 1504. And if that is okay, then they talk about an opaque fence, wall, berm, or landscaping of a height and character necessary for adequate screening of the parking lot from adjacent residentially used property shall be provided. Okay, and if it's approved, it'll go on to a circuit court appeal. And I don't know, maybe you know, can each homeowner extract monies for the decrease in value of their property? Can each business owner do the same?
Mr. Richardson? Sir? I think this is a public hearing. We're waiting to hear from other or opponents at this time.
Okay, that's
We
fine.
can address questions later.
And you do have the petition copy?
Thank you. Any other opponents who would like to speak?
Hi, my name is Kathy Richardson. I live straight down on that point there. You see all that area down there? Right now, it's not filled up, of course, but I don't want a salvage yard outside of my home, and neither do any of these people that are right here. If the pictures got backed up, you would probably see there are cars that are on blocks, there's trailers that are filled with crap, and what's to prevent somebody from moving in there in the summer and just enjoying living in their unlicensed camper? So I am looking at it, not as this, all this legal stuff, but as someone that loves my home, loves my area and the beauty of it, as all these other people do too. So I'm not gonna say much. All I'm saying is that that's a lot of area to turn into a salvage yard, and that's basically right now what it is. If these pictures got backed up, you would really see what it looks like. But That's all, I'm just talking from my heart, so.
Thank you. Any other opponents?
How's everybody this morning? I'm Jeff Fegan. I have the tree service 24712 right off Highway 115. Dell Rapids is a great town. My wife said, well, when you retire, we're going to move into Sioux Falls so I don't have to drive. Anyway, I said, well, I'm never moving from Dell's. It's a great town. We put a lot of money into town. We put a lot of money into City Hall. That building down at the park, that's $1 million. And then if you come from the south, Dell's is a great town, but you come from the south, look off to the east side of the road, it's a junkyard. It really is. I talked to Lance Warren right off the Baltic exit. I know it's more expensive there, but they have room. So, yeah, definitely strongly opposed to this just because it does look bad. It really does. It's an eyesore. It shouldn't be there. Not in our town. Thanks.
Thank you, sir. Anyone else?
Good morning. My name is Nikki Harrington, and we live in Minnehaha County, directly across the street from the property in question. It looks terrible. There are cars on blocks. We're proud of our property, but at the same token, I know that they're charging $30 for a month for each piece that's parked out there. I counted 100, which give or take. So I could do that over on my property. We have 10 acres. I could easily fit 100 junk vehicles over there, which would bring in $3,000 a month for me to do nothing. So we strongly oppose. It was beautiful before, and we'd like to return it back. Thank you.
Thank you. Any other opponents?
Zach, excuse me, Zach Applin from Dell Rapids. I spoke the last time to the permit says licensed. I mean, if it would pass, I would strongly recommend that, some screening, like the property you see there, just to the north of where this opposed junction is. It's all fenced in. There's buildings. It's nice and tidy. You scroll back to some of the previous pictures from the beginning meeting. They're sitting on blocks. They're on the grassy area here. They're just kind of scattered out. Like, this is some of the stuff. This is our houses right back here. This is what we're looking at. You know, flat tires. Without screening, stuff like this, the wind blows, it's going to end up all over the county. You know, so I didn't know if you guys had seen these pictures, but I wanted to point them out to you. I mean, in the last meeting, they said this too all needs to be on hard surface ground. There's a bunch of implement pieces and whatnot to the north. So,
Thank you. Any other opponents? Okay, moving on to rebuttal.
Thank you. Many of the comments that we just heard largely revolve around not creating this, not creating a junkyard or scrapyard in your town. And in the current conditions would tend to indicate that based on the current conditions imposed, you would prohibit the ability to create any semblance of a junkyard. To the extent some of the vehicles of the photos that you're seeing now would be deemed to be inoperable, that would be by definition a violation of the existing conditions. In which case, from a compliance standpoint, you could request a removal. I do understand that much of the unsightly vehicles that you see on these photos either have been removed or there's already been steps being taken by the landowner to remove them. And so I think on an overarching viewpoint, the goal here is yes, of course, we don't want to create a scrapyard or a junkyard in the town. And that's exactly what this conditional use permit is intended to do. Yes, there's no screening requirements, but that was assessed and analyzed by Kevin and suggested that no screening at this time would be required. It, of course, always could change at some point in the future. However, the current conditions adequately protect the neighboring landowners so as to not create a junkyard and to keep the place clean and tidy. And if there are existing cases of technical non-compliance, that's why you have code enforcement, and that's why your city representatives can enforce the current conditions on the permit. Thank you.
Thank you. Okay, seeing no further comment, we'll close the public testimony and open it up to the council and commission for discussion and/or action.
Madam Chair, I guess I can lead us off. So usually when it is not infrequent that the county is hearing cases like this. The procedural posture is usually a little bit different. Usually we get a complaint about a property that is a quasi salvage yard or something and then we are looking at a nuisance action to declare a property a nuisance and then force a cleanup. It's a little bit of the inverse here where we have property owners that are trying to do the right thing and come into compliance, so they apply for a conditional use permit and subject themselves to different conditions, at which time if they fail on those conditions, we now have teeth to enforce. So either way, we're all trying to get to the same thing of enforcement of proper compliance with the property. So when that discussion was had at the joint planning commission level, basically the idea was let's move forward with a conditional use permit with various conditions. I think the most notable condition is that, maybe Kevin can help me with this, but it's July 1. So we put in a date. Usually a conditional use permit is fairly open-ended and it's just ad hoc enforcement if something comes up. But this one explicitly had a time horizon on it, much like how we would deal with a nuisance property to say, clean up your property by X date, otherwise we're going to declare it a public nuisance and we'll force you to pay the cost of the county hiring someone to clean it up. So I think we're all trying to get to a proper compliance, cleaned up property by July 1. So that was kind of the sentiment of the Planning Commission, the joint body, to put something in place that had some rules. I think we can go back and forth on the value of the licensure. I'd be interested in hearing from colleagues from Dell Rapids on the value of the last condition was related to annexation agreement. That's more your territory than ours at the county, so I'd be interested in if that's still of value to you. But that's kind of the procedural standpoint. So for my friends that live in the Dell Rapids community and are looking at that each day, I think we share the same goal of trying to get to compliance. But procedurally, a conditional use permit is what we need to get those teeth. Otherwise, we start back from ground zero and we're looking at a nuisance complaint. And I just don't know if that's the route we want to go. I would rather mutually get to compliance with terms under a conditional use permit. So that's kind of my outlook on the issue, but I'd look forward to hearing from any colleagues.
I believe the city, speaking for the city, that the condition for the pre-annexation agreement, we don't, do you want to speak to that, Sheldon? Sheldon's our code.
Sheldon Jensen, Community Development Director with the City of Dell Rapids. After further discussion with the city attorney regarding the condition to require a pre-annexation agreement, we were following precedent from previous conditional use hearings in this joint area. However, those conditions did involve the construction of a building that did not have utility service, and that property also had deferred assessments already attached to it for the city, which is why that was a requirement at that time. And this property is adjacent to that, but it does not currently have deferred assessments, or they are not applying to construct a building. So after further discussion with our city attorney, we're okay with removing that condition.
Thank you. And I guess, Kevin, maybe you can help. Mr. Richardson has spoken to And I've read through all the references to no outside storage, et cetera. And yet, the conditional use permit is allowing that. Can you clarify or explain just how that rationale works? Thank you.
Sure. So under 703 permitted special uses, permitted special use allows the use of a property that as listed as long as it meets certain conditions as listed. The other aspect of that is that you have to meet the conditions or obtain a conditional use permit. So condition or number A, or letter A, is the communication facilities, warehousing, repair service provided. No outside storage is number 1. Well, so they don't meet that condition, but they can get a conditional use permit to move forward with it.
Okay, so basically, the conditional use permit, excuse me, is overriding that particular statement.
Yes, because of the
Okay.
or in the
Okay.
ordinance. Yep.
Can you say that, what you just said again? Read it to me again.
So the building or premises may be used for the following purposes in the I-1 Light Industrial District in conformance with the conditions as prescribed, or by obtaining a conditional use permit for such use in conformance with articles in Article 19, which would be the conditional use permit requirements.
So is this the first property that has requested this? Because all that's light industrial in that whole area, correct?
Correct.
And there is outdoor storage in some of the other ones,
Correct.
properties. So is this the first of any of those businesses who have requested a conditional use, or have others previously requested?
There have been other outdoor storage requests, and it's usually been in conjunction with other things. That the storage buildings, as you saw in that one photo, does have outdoor storage, and that was part of that permit. There are a few that have outdoor storage requirements in their condition, and there are a few that we need to do some enforcement on as well.
Mr. Richardson had a petition. Is there a procedural process for the petition with regards to the conditional use, or is that just something for a show of force from the people that live in that area?
I would see it as a show of force for the people in the area.
Any further discussion from the Commissioner Council?
Do we need to act on removing that condition, so simply through a motion? Yeah, we need a motion to amend the the list of conditions, specifically number 10, the pre-annexation. So we can entertain a motion to remove that from the conditions.
Mayor,
The pre-annexation agreement clause. It's number 10.
But not the license?
No, this is that we've agreed that there's no need to have any pre-annexation agreement since there's nothing being built.
So move.
Moved by Ron Hagen to approve.
pardon me, Mayor Early, following the instructions I've been given, I believe the county side needs to move first.
Okay.
Do I have a
Excuse
motion
me.
on the county side?
I'll make that motion.
I can second that motion
And the motion is to,
to remove the final condition. Cole?
Yeah, a motion to remove the pre-annexation agreement with the city of Dell Rapids.
to approve the amended COP. That's a motion by Heisey and a second by Kipley.
Madam Chair, can we clarify, are we just amending, or are we actually making a motion to approve with amendment? 'Cause I think we also need to address the license. There were kind of two proposed amendments, so before we get too far, maybe we should make one cohesive, if we're changing, maybe we should change all we're going to change.
Thank you, Commissioner Kipley.
But I don't know, I get counsel for the petitioner saying you kind of have the license. I don't know, I'd be interested in Kevin's perspective on the license status and what value that adds versus how difficult that would be to enforce. So maybe before we make that final amendment to the process, I'd like to hear Kevin's on that condition as well.
Thank you.
So, yeah, condition number 3 requires fully operational, intact, and licensed. Let me see if I can find the proposed condition. So the proposed condition would be all vehicles, campers, and trailers stored on the property shall be fully operational, intact, and property titled. If in the nature and the type of the vehicle, camper, or trailer requires titling under South Dakota law, inoperable and dismantled vehicles are prohibited from being stored on site. I guess I suppose part of that is going to be a function of not everything stored on the property will require a license. So if there's like a tractor or implement on the property stored, that doesn't necessarily need one. But as far as enforcement, seeing licenses, proper license can be difficult because a lot of times we'll be first searching from the road and then we'll have to go onto the property and see where the tags are. Other places, as the noted, there are people who will store campers and not license them until May. And come January, the license has expired or maybe not even put the tag on, but it's maybe licensed. So there is some issues of that, but it isn't impossible to go out and see them because we can go on the property to see if things are functional and licensed.
So Kevin, can you read back to me what the proposed language would be of that revision to subtract out the word licensed?
Yeah, so it really subtracts out the word license and puts it under the titled requirement. So it has to be titled, and that's where the difference comes into play. All vehicles, requirements, and trailers stored on the property shall be fully operational, intact, and properly titled if the nature of the type of vehicle, camper, or trailer requires titling under South Dakota law.
Okay. I'll make the motion then to amend our conditions to adopt that change, as well remove the condition related to the pre-annexation agreement.
I would like to just check with legal counsel and make sure that we're following all of the correct procedures.
Madam Chair, Eric Bogues, Deputy State's Attorney. I'm not sure if there's already a motion on the table. I believe from the county side there was to remove the annexation. So if you're going to make a subsequent motion, it would be
Make it as a substitute motion. I'll make my motion a substitute motion.
And can we make these two separate items and not vote of them simultaneously? Because I will be opposing the amendment or change to the licensure of the vehicles.
Madam Chair.
Yes, thank you.
So as I see it, there are really 4 options in front of the combined board today. There are certainly 2 proposed amendments, which are not necessary if the plan is to reject this in total. If they're going to approve it and want to amend, then yes, the separate amendments can be taken separately together or together with the motion to approve. So there are several different options on how you want to permutate this out, but it's up to the combined board and how you want to address those. But certainly it's your right to vote no on a combined and make that known that you would approve one or separate either way.
So to clarify, we're going to make a substitute motion, and if we could break them out to each amendment.
I can withdraw my substitute motion, and we can proceed with just the motion on the annexation agreement. That seems like there's consensus, and let's just get that across the finish line, and then we can deal with the second one. Is that so? We still have a motion and a second on the floor to just remove the annexation item.
We have a motion and a second to remove. Motion by Heisey, second by Kipley.
Heisey.
Aye.
Kipley.
Aye.
Benega.
Aye.
Blindberg.
Aye. Motion carries. Let me check with my legal counsel. What's the correct order?
Do you want the county to get to final action on the CUP before the city proceeds?
Madam Chair, I think if you're in the amendment stage, it makes sense for the city to follow suit on any amendments before you go to final approval or rejection. Unless, of course, the body would prefer to reject it upfront, that would be certainly more expeditious if that's the intent of the combined board.
Thank you. Hopefully it goes easier on your side.
Didn't know this, it was going to be this complicated. Entertain a motion to, for the city to remove the pre-annexation agreement as a condition.
So move.
Moved by Ronshagen. Is there a second? Do we have a second? Second on the motion?
Second.
Seconded by Mr. Berg. Have the finance officer please call the roll.
Berg,
Yes.
Meyer,
Yes.
Hogg,
No.
Jones,
Yes.
Hanslick,
Yes.
Cavagelli,
Yes.
Ronshagen.
Yes.
Pass. Sorry.
Do you know sign language? Thank you. Okay. Motion's passed.
Moving back to the county side, I'd consider a motion.
Yes, I would renew my effort at a motion to adopt the language removing license status. I think we still have, I guess, just to make a comment in support of the motion then would be, I think by putting the CUP in place, having various conditions, having a set deadline of July 1, which is again very rare for a conditional use permit that we're going to revisit it that soon again. I think we're going to have a very good sense for what proper compliance looks like and what's reasonable. So I think we're better off trying to set the landowner up for success with what can be reasonably complied with. So anyway, that would be my motion, and then I would intend to then make a motion to approve the CUP as amended, but let's just take that one amendment on its own for now.
Okay, I have a motion by Commissioner Kipley. Do I have a second?
I'll second that.
Second by Benninga.
If I may, if I could ask a question to Kevin quickly. If point 3 were to remain as written, and vehicles would have to remain to be licensed, if there's vehicles that don't need to be licensed for some reason, would it still fall under enforcement?
No, if it is
Is there
something
an
that does
exception?
not require a license, such as a farm implement, I would not require a license of that item.
Yeah, now just further to make the comment, I think it's a good idea to keep point 3 intact as written, mainly because I think the quality of the vehicles will be in better shape long-term if we keep that licensure requirement in place.
Thank you. I have a motion by Kipley and a second by Benninga. Roll call vote, please.
Kipley.
Aye.
Benega.
Aye.
Heisey.
Nay.
Bleinberg.
Aye. Motion carries.
It's City Council's turn to act on whether or not we want to make that change to the third listed condition in the conditional use app, so. Entertain a motion.
I'll make that motion.
Motion by Ronshagen to allow the change to the third condition. Is there a second? Seconded by Hawk. Finance officer, please call the roll.
Berg,
No.
Meyer,
No.
Hogg,
Yes.
Jones,
No.
Hanslick,
No.
Cavagelli,
No.
fail. Sorry. Ronshagen,
Yes.
We had, no, yeah, motion did not pass.
Pardon me while I consult with my experts. So the motion failed.
Well, Madam Chair, I think as a county, we have to get to yes on this with our colleagues at the city. So I think we would basically need to reverse course. So I'm just thinking of the motion. I guess I'd like to just get to action on the CUP. I would make a motion to approve the CUP while amending back in concurrence with Dell Rapids that we will retain the original item, condition 3.
Do I have a second?
I'll second that. I'd also like to comment a little further. I did have the opportunity to see this property last year, and I can very much sympathize with many of the opponents in the room. There certainly are a number of unsightly vehicles. I will be supporting the motion to grant the CUP. I'd like to afford the benefit of doubt to the petitioner, but very willing to revoke the conditional use permit down the road if the conditions voted on today aren't met by July 1st. Then also down the road, if they aren't being followed, we could take proper action.
Thank you. We have a motion by Kipley and a second by Heisey to approve. Roll call vote, please.
Kipley.
Aye.
Heisey.
Aye.
Benega.
Aye.
Blindberg.
Aye. Motion carries.
Now the city's turn to act. We would entertain a motion to approve the conditional use application with the reversion back to the original wording for the third condition concerning the licensing, etc. Entertain a motion.
So the motion you're looking for is keeping the licensing back in.
Right.
Or that every vehicle
Right.
must be licensed.
Yeah, reverting to the original verbiage that was listed in the conditional use. Yeah.
So move.
Moved by Hanslick. Do I have a second?
Second.
Seconded by Berg. We'll have the finance officer please call the roll.
Meyer?
No? Oh, okay.
Yeah,
Okay.
I'm filling in
We
here.
have a substitute voice.
Berg.
Yes.
Meyer.
Yes.
Jones.
Yes.
Ronsagen.
Yes.
Hanslick.
Yes.
Hawk.
Yes.
Cavagelli.
Yes.
Motion passes.
Motion is approved.
Okay, that brings us to our next item on the agenda, which is item number 3, a public hearing and second reading on ordinance amendment number 25. Oh,
Chair, Eric Bowe, State's Attorney's Office. I may be confused, and if I am, I apologize, but I understood the county's action to restore the language 3 was not also to approve the conditional use permit. It was just restoring the language, so no final action on the conditional use permit has been taken by the county at this time. So before you move to the next item.
Happy to belt and suspenders this to make sure, but my intent of my motion was to approve the conditional use permit with amendment.
If that was the motion, then
So if
I stand
our
corrected.
minutes will
I only
reflect
heard
that.
the other.
I believe that was stated.
Okay,
Yes, but
thank
thank
you.
you
What I
for
heard.
keeping us in line.
Thanks for clarifying.
Yep. Okay. Moving on to item number 3, a public hearing and second reading of ordinance amendment number 25-02 to the 2001 revised joint zoning ordinance for Minnehaha County and the city of Dell Rapids to add intermodal shipping storage container regulations. Kevin.
Yes, I'm Kevin Hookman from the County Planning Department. These regulations regarding shipping containers in the joint jurisdiction have been already adopted largely in the same format in the larger county area. And they're kind of moving towards the Dell Rapids area, into the Dell Rapids area. Shipping containers are becoming more of a thing as people are using them as alternative sheds and even using them as building components. I think there's a definition of a shipping container. They're pretty easy to pick out, used for intermodal shipping for like on a boat to a train to a truck, and they oftentimes end up on somebody's property for storage. The ordinance will allow for temporary placement up to 90 days for, on any property without any sort of permitting or activation. There's more time needed, such as like a building permit, say a construction of a basement is happening and the property owner moves all their furniture out into a shipping container, while that permit is open, they can keep that shipping container on the property as a temporary storage. In addition to these temporary uses, permanent accessory building can be allowed as well. Any shipping container used as a permanent accessory building would require a building permit, regardless of where it's located on what zoning district. In residential zoning and small agricultural lots, it's a limit to one shipping container on the lot with just a building permit. If there's a desire to have more than one shipping container or have a shipping container as part of a structure, we've seen where you have a shipping container on one side and then on another, and you put a roof between the two. If that is desired, then a conditional use permit would be required for that point. Shipping or egg properties larger than 3 acres would not have a limit to shipping containers, but they would still need to have a conditional use permit. As well as, there's my building components part of it. Still building permit would be required. If shipping containers are used as a primary building, they would still have to follow building code. Engineering will be required to show that the shipping container meets building code and building requirements. With that, I'll kind of bring it right here. So the Planning Commission did hear this item on the January 27th Joint Planning Commission, and they unanimously voted to approve the amendment. This is the second reading and public hearing for the ordinance text amendment. The county commissioners and Del Rapids City Council may vote to amend, approve, or deny the proposed text amendment, zoning amendment ordinance 28, 22, 25. I'm here for any questions.
Thank you, Kevin. Since this is a public hearing, we'll first hear from proponents. If there's anyone here who would like to speak. Any opponents? Seeing none, let's open it up to county commission and city council discussion and or action.
I would make a motion to approve.
I'll second with just a brief comment of thanks to staff for being proactive on this issue. It's not a issue we're having major problems with, but just something we're getting ahead of. And just for our friends in City of Del Rapids, we already have this ordinance on the books in the county, so just looking to come into conformance so our joint jurisdiction has the same language. So happy to second your motion.
So we have a motion by Benninga and a second by Kipley to approve. If there's no further discussion, I'll call for a roll call vote.
Benega?
Aye.
Kipley?
Aye.
Heisey?
Aye.
Blindberg?
Aye. Motion carries.
When we voted on this thing, we called it ordinance 945. Is there, you've got 2502 on the, right?
So the ordinance amendment that I have would be the county's number would
Okay.
be, or the planning department is 2502.
Okay.
But then the as it's written for the county auditor's office, it's numbered 28, 22, 25.
And for the city, it would be 945.
Okay, so that's still, okay, so just to clarify, world of numbers. I entertain a motion on second reading and approval of ordinance 945.
So moved.
Moved by Bob to Mr. Meyer to approve. Is there a second?
Second.
Seconded, Ron Hagen. Finance officer, call a roll.
Berg.
Here.
Meyer.
Here. Yes.
Jones.
Yes.
Ronsagen.
Yes.
Hanslick.
Yes.
Hawk.
Yes.
Cavigelli.
Yes.
Okay, motion has passed.
Okay, that brings us to the next item on the agenda, which is a public hearing and second reading on ordinance amendment number 25-01 to the revised joint zoning ordinance for Minnehaha County and the city of Del Rapids to regulate vacation home short-term rentals. Scott Anderson.
Thank you. Scott Anderson, Planning Director for the county. And once again, this is some catch up to what we've already done in the city and the joint city of Sioux Falls and the jurisdiction and in the county jurisdiction. Today, what I'm proposing or presenting to you is an ordinance amendment which would allow vacation home rentals and short-term rentals in several zoning districts within our joint zoning ordinance with Dell Rapids. So this creates it as a conditional use permit, and then also creates a definition. It also creates some criteria for how those vacation homes or short-term rentals would be administered. So it has been before the Planning Commission. It was recommended unanimously for approval. I'd be glad to answer any questions of the ordinance at this time.
Thank you, Scott. Since this is a public hearing, we'll start with anyone who wants to speak in favor. Any proponents? Any opponents? Seeing no further comment, we'll close public testimony and open it up to the commission and council for discussion and/or action.
I would make a motion to approve.
Second.
Motion to approve by Benninga and a second by Heisey. Roll call vote, please, on the county side.
Benega.
Aye.
Heisey.
Aye.
Kipley.
Aye.
Blindberg.
Aye. Motion carries on the county side.
City entertains a motion on the approval of ordinance, second reading and approval of ordinance 943 for the city of Dell Rapids.
I just have a question first, Mayor.
Yep.
Just to clarify that registering with the state of South Dakota, the state comes in and does an inspection of that short-term rental. Is the county prepared to, because I know for the city of Sioux Falls, the city of Sioux Falls takes over those inspections for the state of South Dakota. So is the county, or are they gonna have the city of Sioux Falls or the city of Dell Rapids inspect? Well, it would be, let me look here if it's a requirement. It says shall, but if they do register, then the state requires an inspection. It would be a requirement of the state, and if the state does not do it, then the county would not take over that responsibility. We would not expect the city of Dell Rapids to take over that responsibility either.
Entertain a motion.
Move to approve.
Second.
Move to approve by Jones and seconded by Berg. Any further discussion? Hearing none, we'll ask the roll to be called.
Burke.
Yes.
Meyer.
Yes.
Jones.
Yes.
Ronsagen.
Yes.
Hanslick.
Yes.
Hawk.
Yes.
Cavagelli.
Yes.
Motion is approved.
That brings us to our last item on the agenda for the joint meeting today, public hearing and second reading on ordinance amendment number 25-03 to the 2001 revised joint zoning ordinance for Minnehaha County and the city of Dell Rapids to regulate long-term lease or rental. Scott Anderson.
Thank you. Scott Anderson, again, Planning Director. What you have before you today is also an ordinance that would be creating a section in Article 12 that deals specifically with long-term rentals and leases of property. Just a little bit of a background, this came out of a court case involving short-term rentals, and a local judge has indicated that it needs to be specified in the zoning ordinance that long-term rentals and leases of properties are permitted. This would be leases of like farmlands or a commercial building at like an interstate intersection where you have contractor storage yards and stuff, but you may have a different owner. So this is just specifying in the zoning ordinance a statement that indicates that it's not the intent of the ordinance to prohibit long-term lease or rental of property so long as the use is otherwise lawful, which basically says we're not prohibiting long-term leasing or use of property. It has to be legal. So I'd be glad to answer any questions. This has been before the Planning Commission. It was recommended unanimously for approval.
Thank you, Scott. Since this is a public hearing, we will have the opportunity for anyone who would like to speak in favor. Any proponents? Any opponents? Seeing none, I'll open it up for commission and council discussion and/or action.
I'll move to approve.
Second.
And a motion to approve by Kipley and a second by Benninga. Roll call vote, please.
Kipley.
Aye.
Benega.
Aye.
Heisey.
Aye.
Blindberg.
Aye. Motion passes on the county side.
For the city of Del Rapids, entertain a motion that approves second reading and approval of ordinance 944.
So move.
Moved by Hanslick. Do I have a second?
Second.
Seconded by Cavagelli. Any discussion? Hearing none, please call the roll.
Berg.
Yes.
Meyer.
Yes.
Jones.
Yes.
Ronsagen.
Yes.
Hanslick.
Yes.
Hawk.
Yes.
Cavagelli.
Yes.
Motion is approved.
Now we have an opportunity for public comment. If anyone would like to address the council on a non-agenda item, this is your opportunity. Okay, I'm looking for a motion to adjourn.
So moved.
Second.
Motion by Kipley, second by Heisey. All those in favor?
Aye.
Opposed?
So,
Motion carries.
entertain a motion to adjourn city council.
So move.
Moved by Meyer. Is there a second?
Second.
Seconded by Hawk. All in favor signify by saying aye. Aye. Opposed, nay. Motion's carried.
We are adjourned, and the regular Minnehaha County Commission meeting will begin at 10:15.
Thank you for your